Thank you.
All right, we're getting ready to call cause number 2016-33379. And I have one additional announcement to make. For those of you who are using the chat feature and are not participants in this proceeding, understand that the court can review the chat as well. I consider that an ex parte inappropriate use of the chat feature because it's commenting on things that are not properly before the court in a context that's inappropriate wholly. And so if you all are going to continue to do that, you will be disinvited, although this is a public forum. Because you're on my screen, I'm reading everything that you're writing. So if you're making, comments about whether or not somebody should get child support or needs child support or needs an attorney or doesn't need an attorney, any of that stuff I'm seeing. So I'm going to caution you to please do not use the chat feature for that. And finally, if you are not involved in the Office of the Attorney General versus George Eric Saldana case, either as a party or a witness, I'm going to ask you to keep your microphones on mute. And I really don't want to see your face, to tell you the truth, because we have enough things that we need to go over this afternoon. But you guys are welcome to observe all you want, okay? All right, so Mr. Joseph,
Thank you.
I need anyone that is expected to testify to please raise their right hand so that they can be sworn. I see Mr. Saldana, I see Ms. Pena. Do we have any witnesses, Mr. Joseph?
Just the parties, Your Honor.
Okay, all right, Mr. Saldana and Ms. Pena, do each of you solemnly swear or affirm and promise to tell the truth, the whole truth, and nothing but the truth in these proceedings?
I do.
All right, and Mr. Saldana, please identify yourself for the
Take the heat
record,
off.
please. Mr. Saldana,
Yeah,
Yes, Judge.
identify yourself for the record, please.
George Saldana. Are you able to hear me?
I am. Ms. Pena,
Carolyn Pena.
and then counsel before the bench, please.
Your Honor, my name is Kelly Joseph. I represent Carolyn Pena.
All right, and Mr. Saldana, you're representing yourself today, is that correct?
Yes, ma'am. I'm pro se.
Okay, and I think we already talked about the rules for interrupting, right? Or getting the court's attention. We just need you to raise your hand. Is that clear?
Yes, ma'am.
It's appreciated. Hold on just a minute. Now, the next thing I need to do is I need to pull the file because I don't know exactly what we're set for. I don't know if this is a temporary orders hearing or what. Because a lot has been filed in the last 7 to 10 days. Okay. Mr. Joseph,
Yes, Your Honor.
can you tell me what's set today?
Yes, Judge, this is our emergency motion for a temporary restraining order.
Okay,
This would have been filed on September the 2nd, 2021, around 3 o'clock in the afternoon, Judge.
Objection, Judge.
objection to, what is your legal objection, sir?
Well, it was denied. We had a submission hearing Friday morning. And I know Mr. Joseph wasn't present, but I was. I came before you. And I think the associate judge denied it at 9 a.m. Friday morning. And so he actually resubmitted it on the 3rd to be correct.
Okay, so what, I don't, I'm just looking at I'm looking at the docket entries.
And Your
And
Honor, clarification, if I may.
I think I know what happened. I think that Mr. Saldana filed a motion earlier, and because he requested a TRO but because there wasn't a motion that accompanied it, it was denied.
Correct.
All right.
And Your Honor, what was set previously that Mr. Saldana is speaking of was an entry on the submission document, I believe, if I can figure out what he's saying there. And that entry, of course, has been reset until tomorrow.
Okay, and I think the submission docket entry was for the order on the last enforcement that we had.
Correct.
And
And the
so-
writ. And the writ.
Right.
Two
And
orders.
so what we typically do, so that we're all on the same page, is if the parties have an agreement and everybody's signature is on the order, then you can do it by submission. But if it is not signed by the other side and we set an entry, we either like you to appear at the entry hearing or file a motion for entry. And then at the entry hearing, we'll take up whether or not the proposed orders reflect the judgment of the court. So that's where we are in that. So we haven't entered those last orders because apparently there's not an agreement on the language.
That's correct, Judge. Nobody informed me about that submission hearing on Friday.
Mr. Saldana, it was passed, so no harm, no foul. Because the nature of the beast is that we would not have heard it. It shouldn't have been set on the submission docket because it was contested. Okay.
Can I get some housekeeping issues I was asking you earlier? Can I go on the record and ask for a few things before we get started?
Okay, we've been on the record the entire time. So what I think I was letting Attorney Joseph tell me so that we're on the same page, exactly what we're here for today. And what I've gathered is, we know what happened to your motion. And then I know that like last Friday, another emergency motion came in the box. And I guess I received it sometime after 4 o'clock and reviewed it and looked at the supporting affidavit and felt that it was important to sign it with some modification. And that was it.
Yes,
So-
ma'am. And that's what I'd like to elaborate on real quick before we get started. August 9th, I filed for a motion for enforcement by contempt with a proposed order setting hearing. It's already almost a month and I have not gotten that order signed. Do you think I can get that signed today before the end of the hearing so I can seek justice for my issues with the enforcement?
All right, I don't know whether or not I've actually seen that, but since you brought it to my attention, I'll look and see if it hasn't hit my box. I don't have anything left over from.
Okay, because I filed a special pro se litigant rights into my case, which states that pro se pleadings are always to be construed liberally and expansively, affording them the opportunity in obtaining substance of justice over technicality or form. And when interpreting pro se papers, this court is required to use its own common sense to determine what relief that party either desires or is otherwise entitled to. SEC versus Elliott. Now, the issue I was having was that I was turned down multiple times for my temporary restraining order because it was not properly pled, or improperly pled is what it was.
Or not pled at all.
I'm sorry?
Or not pled at all.
Okay.
Your Honor, if I may object,
Mr. Joseph, could you, I'm
objecting.
clean.
Saldana, if you'll please stop.
Okay, so Mr. Saldana, this is the way it goes. And Mr. Joseph, you need to raise your hand. I've heard your objection. So he's making an objection, Mr. Saldana. So I need to listen to his objection. You need to respond to it, and then I need to rule on it.
And Your Honor, my objection would be relevant as to this hearing. What he's doing is some housekeeping for some other motions and other hearings, which is really just delaying our substantive hearing that we have scheduled for today.
Mr. Saldana?
No, it actually runs into this hearing. I think Mr. Joseph is going to be quite maybe embarrassed on what I'm saying, so he doesn't want to proceed. And if I may proceed, again.
Okay, so I need to rule on the objection, and his objection is sustained. All right, now, you can continue, Mr. Saldana.
Now, opposing counsel proceeded with a TRO and while holding me to a lawful standard, I would ask this court to treat everyone the same, attorneys and pro se litigants. Opposing counsel proposed a TRO that was altered and things were added to his pleadings. Why weren't things added to my proposed orders or to any of my pleadings? One of the
All right, Mr. Saldana, I'm going to stop you and I'm going to respond. When you filed your initial request for a temporary restraining order, you filed the TRO in a vacuum. You didn't have, there was no underlying motion. You would have required us to file, to draft and file the motion on your behalf, which that's way outside the scope of what we do. On the other hand, if you give us an order and it basically says, you know, or reflects what you've asked for that we can sign, then we will, even if we have to make slight modifications to it. And in a direct point, Mr. Joseph sent us a order which asked for ex parte relief, requiring, or which if we had signed it would have meant that you wouldn't have had any contact or access to your child while this case was pending. And what we did was we modified that so that you wouldn't have any unsupervised access pending a hearing by this court. Now, considering the fact that this TRO was signed late last Friday, and Monday was a holiday and we're not open over the weekend, the fact that you got in this early for an emergency hearing is actually quite stunning. But the other thing I want to tell you, Mr. Saldana, is you all have been in front of this court so many times. As soon as I see your case name, I look at it, okay? And if there's something that needs to be signed, I sign it. If there's a hearing that needs to be set, I move some things around to give your case priority because you have been here so many times.
Correct.
Yeah.
Again, I would refer back to my motion to enforce that was filed 8/9 of 2020.
Okay, Mr. Saldana, we're going to talk about the motion for enforcement later.
So if you could
I
let me,
don't remember what is wrong with that. What I need to do is talk about why we're here today, which deals with what, if any, is going on with this kid, whether or not the child is in danger, whether or not you may have been responsible for the child bearing what looks like bruises all over his little body. This child who is apparently has some disabilities and maybe not as verbal as you would expect a 5-year-old to be. And so again, you know, I get an affidavit and photographs in my box supporting it. And all I can look and see is it looks like the child had bruises all over his body. And now you're chewing me out because you're having a hearing 3 or 4 days later.
no, ma'am. Actually, what my issue is that there was no petitioner's affidavit that went with that TRO. And so
It doesn't have to go with the TRO. It went with the motion, the emergency motion. That's what the affidavit went with. And I know I did. I know I read it. I know I didn't make it up. It was there. So you don't tell me what I can, you know, what I should consider together. Now, if he had done what you did and just filed the TRO and the affidavit, I would not have signed the TRO because there was no motion attached to it. And just because you did it that way, I'm sure lawyers think there's something is filed all the time. And maybe that's what you thought something else had been filed. But that's just not what happened, Mr. Saldana.
I understand, Judge, but he charges $400 an hour, and for him to have a pleading, saying that Carolyn Pena is the petitioner and then supports a respondent supporting affidavit for it, what mistakes are, if you're going to limit my constitutional right for care, control, and protection of my child, I would expect that this court, even in the pleading, it says this court examined this pleading. And so if my rights to my child are going to be limited, I would expect this court to have everything rickety tick on top.
Mr. Saldana, it seems to me that I corrected one of your motions for enforcement where you had the name switched around or something, and I actually corrected it. I remember that you made a mistake on something, and I corrected it. But that's okay. Yes, Mr. Joseph.
Yes, Your Honor. I believe what Mr. Saldana is referring to is that my client is the respondent in this case, as the Attorney General is the petitioner. However, she's the movant in this hearing. So she's both the movant and the respondent as to the affidavit and to the motion.
The affidavit is attached to the emergency temporary restraining order and order setting hearing for temporary orders. And it says the application of petitioner. So I don't understand why you filed them together. And now you're saying, you know what?
Okay, you guys, we're really digressing.
Let's move on.
We're not going to be able to finish our hearing today.
No,
so, Mr. Joseph, do you want to call your first witness, please?
Yes, Your Honor. At this time, I would call Carolyn Pena. Ms. Pena, please state your name for the court reporter.
Carolyn Pena.
And Ms. Pena, are you the mother of Christopher E. Saldana?
Yes.
All right. And we are here today on an emergency motion for temporary orders. Is that correct?
That's correct.
And we're here today because of injuries that were sustained during the periods of possession of Mr. Saldana. Is that correct?
Yes, sir.
Please tell us, if you would. I'm sorry, are you objecting, Mr. Saldana?
Sorry?
I didn't know if you had your hand up for an objection. I'm sorry. I want to direct your attention, Ms. Pena, to August 22nd, 2021. Are you familiar with that day?
Yes. Yes.
Please tell the court what took place on that day.
Well, I picked my son up in Flatonia around 6 p.m. Christopher was increasingly nervous, some anxiety. It was as if he was a little paranoid, kind of fearful towards me. I had my mother and my stepdad with me, and he was just kind of not himself.
Okay, now let me ask you, Christopher's a special needs child, is that correct?
Correct.
So is he able to properly communicate with you everything that happens at his father's house?
No, never.
So when you say that he is acting skittish and all, are you saying that his demeanor had changed substantially since the time you had dropped him off the previous Friday?
Yes.
Objection. Objection.
What is your legal objection, Mr. Saldana?
Speculating.
Overruled.
And Ms. Pena, what happened after you picked this child up?
Ya me voy.
So when I picked him up, we got home around 9:45. I prepared to get my son ready to take a bath to go to school the next day. And I noticed that he had some abrasion cuts on the front part of his foot, and two just, I don't even know what they are, round cut abrasion bruises looking on his back, on the shoulder. Also, so what I
Joy, let me stop you right there. So what did you do when you saw those bruises, cuts, and abrasions and contusions?
well, mean, of course, I took pictures. The next day, I set up an appointment. I tried to set up an appointment with this pediatrician, but they weren't available. So they advised me to go to Texas Children's.
Okay, did you contact Mr. Saldana prior to taking the child to Texas Children's?
I did.
Did you ask him about these injuries?
Yes.
What was his response?
So when I asked him about the abrasions, cuts on his foot, he said that he fell at a water park, that it was superficial, non-emergency.
All right, and you said you took the child to Texas Children's Hospital, is that correct?
That's correct.
Okay, and Judge, at this time, I would offer exhibits A, B, and C into evidence if there's no objection.
Um,
And I have tendered these to Mr. Saldana by email, Your Honor.
I'm gonna object to C and D.
Basis of,
I'm sorry.
I said, what is your legal objection?
Lacking foundation. There's no, I don't know if it's foot. It looks like it's been altered, both pictures. There's no time stamp, no time date. It could have been on the 22nd. It could have been the 23rd. It could have happened last Monday.
Is
So-
this
Okay, I'm
exhibit
gonna
B?
sustain the objection as it relates to lacking
I'm sorry.
foundation at this time.
I'm sorry, Judge. I'm
Okay,
having a,
however, I said, I'm gonna sustain that part of your objection dealing with it not, he didn't have a proper foundation. But you did give him an opportunity to do that. He just asked whether or not you had any objection to A, B, or C, and you identified those that you had an objection to. So he hasn't, still has an opportunity to lay a proper foundation. He's just not gonna get it through by agreement. Okay.
Judge, with due respect, is there any way you can pull that microphone? Because it's.
Well, somebody asked that this be live streamed, and I was gonna, I mean, this is stuff that we've been having before, and right now, if somebody is trying to come in, I can't get them in because the whatever that scrolling list is frozen. And I can't do anything without logging out.
Okay, that's fine.
So if you need to make adjustments, you know, it's gonna be kind of hard.
So Judge, if there's no objection to exhibit A, I would offer exhibit A into evidence.
All right, exhibit A is submitted.
And as to exhibit B, Ms. Pena, do you recognize the document entitled Exhibit B?
Yes.
And is that the provider notes from Texas Children's Hospital?
Yes, it is.
And were these the notes that they gave you upon discharge of Christopher from the hospital?
Yes.
And are these a clear and accurate representation of the notes as you have them?
Yes.
And do you keep these kind of notes in your ordinary course of business as to record keeping for your child?
Yes, I do.
And you've testified that these are accurate and that you've not changed them in any way. Is that correct?
That is correct.
Your Honor, at this time, I would offer exhibit B into evidence.
Mr. Saldana,
No objection.
all right, exhibit B is submitted.
Thank you. And then as to exhibit C, Mrs. Pena, do you see the document entitled Exhibit C?
Yes.
Please tell the court what that is an exhibit of.
This is Christopher's foot with
Is that his left foot or his right foot?
Excuse
That
me,
is
can
his
I object to C?
left foot.
Okay, now remember, we have a record, Mr. Saldana, and I specifically asked you, if you have an objection, I need you to raise your hand so that I can acknowledge you. And I usually let them finish the sentence and then I'll circle around to you, okay?
I'm sorry, Judge, I'm having a hard time hearing you.